While discussing section 141 to 143, we understood that asking leading questions is valid during cross-examination. What are the other questions which are lawful during cross-examination? Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Evidence Act, we were focusing on chapter 10, which is all about examination of witness, covered between section 135 to 166. And in that series, this is my 8th video where we are going to cover section 146, which is all about questions lawful in cross examination. Now, one request I have here is please stay till the end, because sometimes it gives huge perception, but I have to also give an idea as to what are the limitations. With that, I am taking you to slide number 1. Section 146 discusses about questions lawful in cross-examination, and let us start the discussion with the Bare Act provision, which says when a witness is cross-examined, he may, in addition to the questions hereinbefore referred to, be asked any questions which tend to test his veracity, to discover who he is and what is his position in life, or to shake his credit by injuring his character, although the answer to such question might tend directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. The section looks little lengthy, but it's a very easy section. Now, before reaching to section 146, in chapter 10, we have already covered 11 sections starting from section 135 to 145. There we have understood several aspects, like I have already told that leading questions are allowed during cross-examination. Now here under section 146, three other different category of questions which are lawfully allowed during cross-examination are discussed. Among them, the first one is to test the veracity or the truthfulness of the witness. There can be questions which are testing the credibility of the witness, that is allowed as per section 146. Then we have second category of questions, which is to discover who he is and what is his position in life. Now, during cross-examination, there can be questions as to who he is in the society, what are his family, what is his connection with the party that he is giving witness to, what business he does in the society. All of that can be questioned. Now, that is the second category of questions which are allowed under section 146. I am sure understanding category 1 and 2 is not that difficult, because the first one is focusing on the truthfulness of the witness, whereas the second one is focusing on the background etc. of the witness. But the third one is very important, and understanding this is very critical and most important. Here what happens, to shake the credit of the witness, the questions are asked in such a way during cross-examination, the answers will injure the character of the witness himself or herself, and these answers given might directly or indirectly criminate the witness, or might directly or indirectly expose him to a penalty or forfeiture. Here the witness himself or herself is in danger. That is the importance of subsection 3 of section 146. I hope you are understanding. Now, nothing to worry. If that is a straight case, no one will come to witness box. So there are certain provisions which are protecting the witness also. Like for example, under section 132, there is a provision which says no such answer which a witness shall be compelled to give shall subject him to any arrest or prosecution, or be proved against him in any criminal proceedings, except a prosecution for giving false evidence by such answer. Now that is section 132 proviso, and along with that section 148 also gives certain protection to the witness. Now there we are discussing court to decide when question shall be asked and when witness compelled to answer. Now there court will decide for which question the witness is compelled to answer. There court protect the witness also, because otherwise no one will come and stand in the witness box. If he or she is coming and standing as a witness, and if every questions of his or her life is asked, then there is no security for anyone. And for that I also have a case law, but before moving there is a proviso, and let's try understand that. Proviso is basically very simple here. In rape case, when I say rape case, Indian Penal Code 1860 section 376 and all the amendments came via Criminal Law Amendment Act 2013 and 2018, that is 376A, 376AB, 376B, 376C, 376D, 376DA, 376DB or 376E. Here in all these cases, when the victim is standing as a witness, there you cannot injure the character of the witness. Now that is not allowed, and that is one exception when we are discussing about section 146. There you cannot refer any of her previous act or her being very casual or anything like that. You cannot discuss all of that and injure her character. That is the exception or proviso available for section 146. Coming to the case law, I have this very important case law as far as section 146, that is Dr. Baburao Patel versus Bal Thackeray. Here, as I already told, subsection 1 and 2 of section 146 are not that tricky, but subsection 3 is a very tricky subsection. So we need to be very careful when we are discussing about that particular section. Now here comes the case law where there are two parties, both of them having their own newspaper. Baburao Patel had a newspaper by name Mother India, and Bal Thackeray had a newspaper by name Marmik. Now what happened here? Bal Thackeray in his newspaper Marmik one fine day wrote an article about Dr. Baburao Patel, and according to Dr. Baburao Patel, that particular article is criminal intimidation or insult as per section 504 of Indian Penal Code, and Bal Thackeray should be punished according to section 506 of Indian Penal Code. Now that is the case. Further, while cross-examining Baburao Patel, the counsel of Bal Thackeray asked Baburao Patel about an article which he has wrote in Mother India about Nehru's corruption, etc. Now here court very clearly said that this question is not intended to shake his credit by injuring his character, because the question is not aimed at his character at all in relation to a matter in issue. The question is patently asked for the purpose of scandalizing and embarrassing the witness. Such a question is not allowed under section 146 of the Evidence Act, and as already mentioned in the quote below, it was not shown how this question was relevant under any other provisions of the Evidence Act. Now that is what held here. And in the first stanza, I have given the example of a medical man. Now, if the medical man is called to give a witness on the wound, and when he is standing in the witness box, if you start inquiring all his earlier surgeries, etc., then nobody would come and stand in the witness box. So the questions under 146 need to be relevant to that particular case. That is very important. And there are other provisions, as I have already told, like section 132, 148, etc. will protect the witness. Now these are the different aspects that we need to understand while discussing section 146. As I say always, while studying Indian Evidence Act, you cannot rely upon a single section. It is always understood with the previous sections as well as the later sections. So we have to understand the act as whole before implementing any one particular section. That is another important aspect we always need to remember.
While riding or driving, speed thrills, but we also need to remember it also kills. uploading this session. Please subscribe our channel. Please like, share and comment our